Hi, thanks for checking out our videos here on the Right Law Group video page. Today I want to talk about the differences in protection orders in domestic violence cases. So this is specific to Colorado. It may be beneficial to other people, but we're only talking about Colorado today. What happens in a domestic violence situation is there are the criminal charges that can be leveraged against someone, and there are also civil charges that can be leveraged. So the terms that lawyers use are, in a criminal case, there's what's called an MPO. It's a mandatory protection order. And in a civil case, there's a TPO, which then turns into a CPO, which is a temporary protection order, which is then transferred into a civil protection order or a permanent protection order. Now, these are handled by different judges, they're handled by different courts, and there's different processes for getting this done. What I like to do is kind of explain the process to you, and then if you have any questions, as always, feel free to leave any comments below or contact us directly, and I'll get you more information as I can. So, a civil protection order is very different from a criminal protection order because, one, you have to actually, as a petitioner in the case, you have to file for a civil protection order. So civil protection orders are put in place for individuals who are victims of domestic violence. For today's purposes, we're talking about domestic violence, but you can get a civil protection order for anyone. It has to be a showing that you feel that you are in imminent danger, that there has been some history of either physical or mental abuse or threats, something that means that you are in some way concerned about what's happening in this relationship with this person, and that you have a reason to request a protection order to be permanent. Otherwise, you don't feel safe without that protection order. And that's a very generalized layman's terms way of putting it, but just kind of giving you an idea. What happens is any person who is seeking a civil protection order must go file for a protection order themselves. It is not something that is automatically done. Conversely, in the criminal realm, when you are charged with a domestic violence offense, even if you're not convicted, as soon as you are charged and put into the system, there is then a mandatory protection order entered on your case. Now, there are similarities between the two as well, but the main difference is civil protection orders have to be individually requested, and then there has to be a hearing on whether or not it is made permanent. Criminal protection orders are automatically put on you as soon as you have a criminal charge for domestic violence, and they remain in place unless you have some hearing in court, or if there's some modification. They will remain in place for the duration of the time that your criminal case is pending and open. And the reason I separate those two is pending means leading up to any potential conviction or plea, and then open is if you're then on probation afterwards, or if you have any type of jail sentence or anything following a conviction, the protection order is still in place during that time. A criminal protection order only goes away after the entire case is closed. A civil protection order never goes away if it's granted as permanent, unless the people in that protection order, one of them, asks to readdress the protection order. Now, when you're looking at criminal and civil protection orders in domestic violence cases, a lot of the times what will happen is, let's say there's a domestic violence case where someone calls the police saying that they are a victim of domestic violence. The police come and arrest that person, that if they have probable cause, they come and arrest that person. The court process is set, and the ball gets rolling on getting everything on the criminal side, including the criminal mandatory protection order in place. A lot of the times, though, the victim can then go file for a civil protection order. Now, for a civil protection order, there does not have to be a pending criminal matter. You can file a protection order on anyone for anything. I'm not advising you do that. I'm just saying there's no basis where you have to have that criminal protection order already in place. Anyone can file for a civil protection order. However, in domestic violence cases, what often happens is the criminal case happens, and then the civil case is shortly thereafter, where the named victim is asking for a protection order based on that. Now, if you're requesting a civil protection order and there is a pending criminal case, it's often very helpful to the civil judge to see, okay, there's this criminal case pending, and it lends some credibility to your request for that civil protection order. It does not necessarily mean, though, that the person seeking the civil protection order will get a permanent protection order against the person just because a criminal case is pending. For example, and I have my client's permission to talk about this, I had a case very, very recently where my client was charged with domestic violence and had a multitude of domestic violence charges leveraged against them. They told me repeatedly that they are untrue. This person is just fighting against them, trying to basically uproot their entire life and destroy the career and the life they've built. And I've been fighting that on the criminal side for them. Shortly after being charged, this individual then was served notice that they had a civil protection order hearing pending. What happened in this case, and I'll just cut to the chase very, very briefly, is I represented my client on both. I went to court for the civil protection order hearing, and I showed the judge, because the burden of proof is lower in a civil protection order hearing as to whether or not they grant that permanent order. I showed the judge all the ways this other person's story did not make sense, it didn't hold up, and I pointed out all the holes in their credibility and the flat-out lies. At that civil protection order hearing, the judge said that they were not going to grant the civil protection order to be made permanent because there was not sufficient evidence to substantiate that charge. Now, this is interesting for my client because the burden of proof in a civil protection order hearing is that the judge has to find by a preponderance of the evidence that the issues surrounding the need for the protection order, so usually it's a specific incident, and in this case it was a specific incident alleged, that this incident gave rise to the need for a permanent protection order to be granted. In this particular case that I'm talking about, and I know I'm being vague, I want to protect my client's basic facts as much as possible. In this particular incident, the judge found that the allegation that was the basis of these criminal cases was not even enough to rise to that level of preponderance of evidence. So legally, and I know I'm throwing a bunch of legal jargon out at you, but legally what that means is a preponderance of evidence level is about here, and then for reasonable doubt, which is what everyone knows as the criminal standard, beyond a reasonable doubt is what you need to prove someone is guilty of a crime before a jury can convict them. Beyond a reasonable doubt is here. So in essence, what happened is the civil judge said, you're not even to this threshold, which then gives me the leverage when we go to court on the next date to tell the DA, it wasn't even found at this level, so we can't convict him at this level. You can't keep going because the judge already found on the record that there's not enough for the lower level, much less the higher level. So in that way, it actually turned out to be a good thing for my client that this other case was pending because we're able to use the transcripts from that event and go to the next portion of the criminal case. Oftentimes, however, it's very, very detrimental to my clients to have both of these pending because it takes a lot of time, a lot of energy, a lot of money to fight all of this. And it's very difficult because you've got the civil protection order and the criminal protection order, and anything you do could possibly be a violation. So, for example, in cases where you have both pending, let's say someone says that they are a victim of domestic violence, they call the police, the other person is arrested, and that mandatory protection order enters. At that time, the person who has the charges against them, they haven't been convicted, they're just pending, but that person is not allowed to contact their significant other in any way. It would result in a new case. Further, the person then goes and files for a civil protection order, and for the way that a civil protection order works is when they file a motion asking for a civil protection order, the judge automatically grants a temporary protection order for a 14-day period. Now, after that 14-day period, the other party comes in and says whether or not they want to fight the protection order, and then generally what happens is, assuming the other person doesn't also want a protection order to enter against them, which no one ever does, that then goes to a permanent protection order hearing. But while these two things are pending, let's say that my hypothetical client who has both of these things pending against them gets a text message from the victim in the case. And the alleged victim says, hey, I really want to talk to you, can you call me? This happens so often, it's just sad. Because either both parties don't understand the process, they don't understand what's going on, or more often than not, the alleged victim is trying to get the other person to reach out to them so they'll have more charges put against them. If my client in this situation were to respond, even if they responded, no, I can't talk to you, in a text message, verbally, or over the phone, under the law, that person could then report to the police department that my client violated 2 protection orders. And this has happened so many times, I can't even count. Then what happens, if it's in a text message, she takes it to the police, and I'm saying she in this hypothetical situation, she takes it to the police department, says, hey, look, here's this text message from this person, they responded to me, it's a violation, and the cops will then go and charge them with not 1, but 2 criminal offenses. Because if you violate a mandatory protection order on the criminal side, violation of that protection order is a Class 1 misdemeanor. If you violate a civil protection order, it is a Class 2 misdemeanor, and they are separate offenses. So then this poor person that I have who has these charges against him and the civil protection order and is responding, trying to do the right thing, now not only has one criminal case, but 3. So I know I just threw a lot of information at you, but it's incredibly important that you understand that if you are in a situation, whether you have an attorney or not, if you're in a situation where you have been charged with domestic violence and you have also gotten a civil protection order pending against you, either one of those, if you contact the other person, you are going to get criminal charges for both of them. Also understand that if you are the person who has said that someone committed an act of domestic violence against you, even if you did it out of anger, even if you're upset, even if it's not true, that person cannot contact you without it being a criminal offense. That's why it's so important that you get representation in these cases with domestic violence, because there are so many different ways they can spin completely out of control and do much more damage than they originally would have. Again, I know I glossed over a lot there, but the key points to take away are this. There are 2 different types of protection orders, a criminal one and a civil one. If you violate the civil one, it is a Class 2 criminal misdemeanor. If you violate the criminal one, it is a Class 1 criminal misdemeanor. Both of them can be issued for the same incident. One of them lasts for the duration of the criminal case. One of them has the potential to last for all time. And it is incredibly important that you have an attorney representing you on either one of those, just so that you understand exactly what the implications are regarding your personal life, what you can and can't say, who you can talk to, and make sure that you protect yourself as much as possible. A little bit later on, we'll be doing videos on different aspects of these orders and kind of what you need to know about them. But if you have any questions now, if you have any suggestions, like I said at the beginning of this video, please just let us know, and we'll be happy to help you out. Thanks so much.